in the interest of time, while we wait a couple more minutes for Priscilla, I think it would be helpful to pull up the memo, the staff memo, to go over their recommendations. Um, and I'm going to particularly be on page, I guess, 16 is where the recommendations start. All right. Excuse my chewing. In the interest of time, I'd like to get started. I want to reiterate that these are not final recommendations, not voting on anything. We can add, subtract, etc. This is just to provide further guidance to staff as we refine these recommendations for our eventual report in November. There's, I believe, 6 recommendations in the memo. I'm going to go through each one. Before, as we go through them, if there are any refinements on them that anybody would like to make at this time, please do so. And then at the end, I will ask if there's anything that we should add. Sounds like a good way to go forward. Any objection? All right. The first recommendation is reiterate the need to improve data access. In our 2023 report, we asked for more data from CDCR, DOJ, and the Judicial Council. And this was primarily a part of the Prosecutor Data Act, which was passed but has not been funded, so nothing's come of it. Is that AB 2418, Tom?
Yes, that was the DA data bill in 2022, I think. And then this recommendation that you're referring to that we made previously was a bill that Assemblymember Culver did in 2023, I want to say, that didn't make it through. So there's both the bill that passed, that's, if you look in the penal code, it says what data prosecutors are supposed to collect and disseminate as appropriate, but it actually becoming effective was contingent on funding, which has not yet occurred. And then in addition to recommending funding that so that this, data process would actually begin, the committee also recommended that CDCR, the Department of Justice, and the Judicial Council put out additional data and reports they're already producing for the most part. And then also that there be some changes to the Public Records Act to allow greater access to police reports. So it was, a constellation of things that would increase data access for data that's very relevant to RJA claims and is mostly dealing with data that's already collected. It's really just funding the prosecutor data that would, be a really big new lift.
And am I correct in saying that this is just a reiteration of past recommendation? This is nothing new, but except perhaps we're just putting the gloss of the RJA on it. Is that correct?
It was always in terms of the RJA. So it was a good idea then. It's a good idea now. I think we've helped this a little bit with the dashboard that you show that we're going to make public soon and continue to expand upon maybe some similar efforts like that. So it's almost like it's become a DIY effort, and that doesn't seem appropriate given the nature of these issues.
Sorry to put you on the spot in public, but do we have a rough timeline on when the dashboard might become public?
We have a rough timeline, sure. We're hoping for this summer. That's what I've been saying, and we are working very actively on making that happen.
And just so everybody knows, one of the reasons why it's taken time is because Tom and CPL and the folks have really gone painstakingly through all the data to make sure that and working with CDCR to make sure it's actually accurate. And so it's going to be worth the wait.
Yes, and as I always say, the Office of Research at CDCR are wonderful to work with and been very helpful. So I'm happy to say that in public as much as I can.
Chris Chambers for president.
Okay.
All right. Number 2, clarify the disclosure obligations extend beyond prosecutor offices to police and sheriff. We've heard a lot of reason why that is necessary. I think it speaks for itself. My understanding is it's currently not in law. So we should make that explicit. Tom?
Yeah, this is a real clarify what the law already says kind of thing, because we heard and the work, and especially that Joy was doing and talking to folks around the state, that some places this is taken for granted. I think you heard Simon from Contra Costa speak to that he was talking about how long it takes to get this material. But in other places, I think prosecutors have argued that they don't need to get anything from police departments and similar.
We also heard that the prosecution office alluded to the fact that courts have this data. Tom and I spoke a little bit about this. There might be some constitutional problem with requiring courts to be part of the data disclosure, but I'm not opposed to at least exploring that as a possible other entity to get in on the act. All right.
You should ask Mary what she thinks of how
yeah.
the courts will react to that.
They're going to love it.
If you give them money, they're okay. I mean, I think in order to get some of these things funded, I think getting more information from the prosecutors and the defense attorneys about how much money they're spending on this is helpful. Because even if that's not state dollars, if you have individual members who realize their county is spending a lot of money on collecting it, that can help move something through a money thing through the budget process or not object to it. So I think that the people we heard from all said, spend all these hours on it. I think getting that information for as much as you can from defense attorneys and DAs when it's actually brought to the legislature can be helpful.
I think on that same point, I haven't read it fully, but I think there was a ruling from the I don't know the name of the agency that rules on whether something is a local
state mandate, yeah.
And they said RGA claims, because it's entirely, I don't want to mangle it, basically said it is a local mandate. So
then some of the counties might be trying to collect that money. I mean, that becomes a whole other issue on whether it's collected or not. But I think those arguments, and if some of this would be budget funded, so if the law is already there that they have to do it, or that makes more sense than just sticking it as an unfunded thing. So it makes sense to collect as much information as possible of how individual offices are spending this, and that in the long run, some database for at least some of this information might be better.
And of course, money is always hard to come by, but it does seem kind of bipartisan in that both VAs and Defense Council want money to make this data more accessible. All right. Number 3, expand the possible remedies, or at least clarify what the remedies can and should be. The first is, I think, that makes entire sense that dismissal in misdemeanor cases maybe should be required, but at least a possibility, perhaps a default. But my understanding is, what's the current standing on that, Tom?
Well, dismissal is not listed as one of the remedies that's on the list in the RJA, and only court to really consider it has said you can't dismiss a case and you have to pick from that list, which then means there isn't much to do in misdemeanor cases, because the remedies are things like dismiss a special circumstance or an enhancement or special allegation, or reduce to a lesser included, and those just aren't really going to be relevant most of the time.
Right. So there's this problem with the statute. Again, I think this is something that we can clarify, that the enumerated remedies are is only a partial list, including but not limited to. That language does not currently exist, and that's basically what we should say. And include dismissal, which I guess is not already on the list.
Correct.
Number 4, formalize some kind of large-scale relief, kind of a quasi-class action. We may want to avoid the specific term class action, but allow sort of a collective litigation to proceed. I think that there's some, I seem to recall, I was talking again with Tom offline, that there is some, at least case law, very much discouraging class action and habeas cases. That doesn't mean that we can't pass legislation otherwise, but that's what I think. Heidi?
this might be a place to include as an alternative or as a smaller step toward this, the idea that we were bandying around, where if we had some agreement on a standard for prima facie and we could mandate the development of a data bank or a pool of experts who could say, and I understanding it wouldn't preclude other cases with different situations, but that would be sort of everyone would have access to that to file and meet their prima facie and get an attorney to further specialize their case. That might be closest we could get to class action, or something that requires the DA's office to, if they have a claim that a special circumstance for drive-by shooting was racially disparately applied in the 1980s or 90s, or whenever it came into law, that then they have to go back and look at those other cases in their office or send out a note like they do when they get Brady, like send out a letter. We've made a determination that there was a disparate impact on people of such and such a race in the application of this particular enhancement. And then, then people pursue their own individual cases. Obviously, all the cases are individual, but just like if we could set that up, we would overcome a lot of the hurdles of people not being able to file pro se, not being able to get the data, and all the expense of the litigation to get the data. And to me, it feels like it's a subset of being able to get class action or, group relief for people who are similarly situated.
Yeah, I like that idea. Some kind of notice. Might also add to the list about limitations on protective orders, because if a lot of this is being stymied by protective orders that don't need to be there, maybe we can provide some guidance there about what is really subject to being under seal. These couple of things that Heidi and I have just been talking about may also fall under recommendation C. It's not necessary. I mean, 6, sorry. We may not need to make that distinction, but I'm just noting. 5th recommendation is to strengthen appellate review of A1 and A2 claims. These are claims of explicit racial bias stated by police or judge or prosecutor. My understanding is right now appellate courts are saying, even though it might be completely in the record, you have to begin your litigation in trial court, which we think is,
Well, I think it's even more stark than that, which is that the legislature amended the RJA a few years ago to say if your claim is based on the record, you can raise it on direct appeal. Now, it didn't use the right kind of exact kind of magic word language that a few appellate courts have wanted to say, which you can raise it for the first time on direct appeal. So even though the legislature seemed to have taken this step of allowing these claims to be raised on appeal for the first time, if it's based on something said in the courtroom, there doesn't need to be any real development of it. That was seen as an appropriate thing to do, albeit unusual for appellate procedure, given the gravity of the claims in the Racial Justice Act and just the speed the legislature wanted to act with. The courts have basically said, no, it doesn't mean anything. You have to preserve the claim below. So it would sort of be restoring what seems to be the original intent of that amendment.
And I also think it's not that unusual. Courts can and should make rulings when it's entirely enclosed within the record, in which this would be the case, even if it wasn't raised below. Excuse me. I have a teenager who needs a car. All right. And then the 6th recommendation is to develop a model process for determining statistic-based claims. And what we're currently thinking is to pass this as a piece of legislation may be impossible, maybe even not ideal, but perhaps we could produce a white paper or even a website or something that could go through some of the steps, that we could work with Steve and some statisticians to explain some of the basic data that you might need, maybe even include forms, just to make the steps quite clear and accessible, especially to indigent and incarcerated folks. Any thoughts? All right. Any additional recommendations that we didn't touch on that we think staff should continue to track down? All right. Obviously, if things come up in the future, we can always add to the list and subtract the list. We're going to wrap up our conversation about RJ right now, except when we come to public comment. I just want to say, staff, you guys have done an incredible job yet again. I thought it was a really great presentation. It was a good conversation. This is a really important area of law where not enough has happened. And I think that we can't obviously solve the problem altogether, but I think we can be part of the solution, and I want to really sort of shine a light on it and continue to move the ball forward. So it's really it's disgusting that only one statistics-based, systemic-based piece of case has prevailed, when I think everybody knows how pervasive racism is in the justice system. I know that they're hard cases to make out. I know that it's complicated math, but it's been almost 5 years, and we should do better.
You know, one thing I'll add to that is, and this is something I think Joy and I will continue to look into, is North Carolina's Racial Justice Act, which was repealed, only applied to death penalty cases, but the courts there said, well, you can't repeal it to people who had already started the claim. So it's actually still being decided. There was a big decision a few months ago granting a claim, essentially. Now it's, you know, the law is a little bit different, but I wonder if we might have some things to learn from that experience as well. Though obviously with the death penalty, the just the history and the backdrop is much more investigated than it is for many other things, but maybe there's something there.
I totally agree. I think North Carolina obviously comes up. My only concern is sometimes death cases swallow the rule or whatever, just kind of dominate. And I would hate to have specific legislation that would apply only to death cases. That should apply to everyone.
Well, I think it uses some of the same statutory phrases that we do in ours. So they're just, you know, they've had more time to make progress with their claim. So it's might be instructive, but maybe not, because the death penalty context is so different.
All right. With all that said, any last words on RJA for today? Good. Again, I'm going to reiterate my thanks to staff, in particular, our panelists, all of you guys. I think that this committee can actually be a leader in pushing this forward, and I want them to make that a priority for us. Okay. Next issues. Some administrative pieces, business to take care of. In particular, we need to approve the minutes from the May meeting. I move to adopt those minutes from that proceeding. Do I have a second?
Second.
Anyone opposed? Okay, we're going to approve those minutes. Thank you. Now we're going to have additional presentations from staff, which will cover the bills that are pending in the legislature related to past committee recommendations, an update on crime data, and some stuff that staff has been working on from our meeting in April. Tom, take it away.
Great, let's get into it. So the legislative update is pretty short. We have 4 bills that are still pending, and 2 of them are been made 2-year bills, which means they're not really an option for anything that's going to happen this year. But the 2 that are still out there are AB 1036 from Assemblymember Schultz that expands and clarifies some issues with the current post-conviction discovery statute, and AB 1231 from Assemblymember Al-Hwari, which would create sort of general felony diversion for many types of cases. And I know Judge Espinoza has been involved in this one a little bit.
And what's the status? They've passed, where are they?
They've all passed their first house, and I think everything is pending in the appropriations committee, which can often be a black box for what comes out of there and why. But it's about another month before we'll know what happens there.
I just want to reiterate that 1231, I think, is particularly good, and I want to, triple down my recommendation for it. It allows judges to order a mental health treatment in lieu of a felony conviction when the judge decides in that individual case that it's in the interest of justice and won't interfere with public safety. Seems very logical to me. I appreciate that there are strains on mental health services in the state, but if a judge thinks it's the right thing to do in the individual case and the services are available, I don't understand why we shouldn't allow them to do that.
So, Ms. Espinoza, I testified on that bill last week, and it actually allows judges the discretion to divert any non-serious, non-violent felony, regardless of whether or not the person charged suffers from a serious mental health issue. So it allows judges to avoid a first felony conviction for persons charged with a variety of non-serious, non-violent felonies. It went through the Senate Public Safety Committee last week. It was pretty non-controversial. There was one no vote. So.
Tom, is it limited to just non-serious, non-violent felonies, or is it all felonies?
That's my understanding. I think there's even some carve outs for those as well.
Okay.
And then these other two bills are the 2-year bills. One has to do with benefits overpayment. This is a recommendation the committee made, I think, 2 years ago. And then the other has to do with limiting consent searches during traffic stops, similarly based on some of the RIPA data and other research we looked at. All right, so that's the legislative update. We'll now move to crime statistics. So I'll just give the headline real quick that compared to 2023, violent crime decreased 2% and property crime decreased about 8%. So that's great news. And I'll get into some of the specifics. And, crime has been sort of going down all over the country. So this isn't really a particularly California specific story. And again, all this data we're going to look at, it's what the California Department of Justice publishes, and this is the overall trends back to 1969. Property crime on top, violent crime on the bottom. I'll let that stay while I give my my caveats and disclaimers. So this is all what's local police departments and other law enforcement agencies report to the California Department of Justice. It's reports to those agencies of crime. So it's, if you don't call the cops, it's not going to be in here. And the other big caveat is the data we have from Oakland for 2023, so not 2024, but the year before. Everyone knows it was wrong, that they really, it was almost like someone added a few extra zeros to the reports of violent crime, particularly aggravated assault. It was such an error that it actually showed we had a violent crime increase in 2023, when it looks like we may have actually had a decrease, and it actually affected nationwide violent crime statistics. So it's like really egregiously wrong. Everyone knows that, but it is still the number that is in the data you get from the Department of Justice. So I've updated this with the numbers for the violent crimes in 2023 that Oakland reported publicly. So if you look at DOJ's crime reports, you're going to see some slightly different things than this, but this uses, I think, better data. And I'm actually trying to figure out why they are still reporting that old data, and if there's a statutory issue, maybe it's something we can weigh in on. Mike, were you saying something?
Yeah, this is really ridiculous. I mean, it affected the statewide crime rate data, as Tom said, even the nationwide crime data. It is an absolute error. Everybody knows it, and DOJ is refusing or unable to, or whatever, to correct the error. I don't know if this is something that you might be able to help with, Professor Ochin, but it's there's a footnote, or as Tom said, buried somewhere, it says there's an error here, but this should be fixed.
So we're trying to get to the bottom of it, and maybe something they can do internally, but if they need some statutory help, hey, why not? Okay, so I've shown this chart to you all so many times, but I just feel like we can't show it enough. The especially and I'll show a separate one on violent crime. So you see violent crime peaked in the early 90s and has gone down a lot, and obviously here during the pandemic there was an increase in California, as there was and everywhere in the country, but we're now coming back down. So some specific offenses, as I said, all violent crime down about 2%, homicide down 12%, which is one of the biggest drops in homicide ever. Slight increase in rape, around 2%, and robbery and aggravated assault also down slightly. Professor Ochin, yes.
I know it's always dangerous to ask for like causation, but do you have a sense of, why this is? We'll often credit law enforcement for decreases, but there have also been studies that show, in communities that are more highly resourced, that have more nonprofits, right, that they are responsible more so than, say, policing for decreases in crime across a number of different categories. So I'm wondering, do you have any, anything that you might want to offer as speculation as to why we're seeing these trends, either, where there might be an increase or where there have been decreases?
I think everyone agrees that the early days of COVID, when everything was shut down and there was just so much, I don't know, kind of free floating anxiety, that did something. What the exact channel was, whether it was sort of schools being shut down or after school programs or other community programs, that's one analysis I've seen, is that that you can sort of show causation between those things, especially if you look at other incidents in American history where schools have been shut down as a result of a natural disaster. You see similar increases in violence. And the other one of the slide I'll show later on shows that our arrest rate has also not really gone up as a result. So there doesn't seem to be an increase in law enforcement activity, at least in arrests. So it just seems to be the gradual return to sort of the pre-COVID normalcy in many ways that we're seeing. Because if you look at the trends, if we kind of took out the COVID years, this is 2019, and you'll see this really with homicide too, is, we're kind of continuing on that trajectory we were on, particularly with property crime, where 2019 is here, 2024 is here. So it's, we know that COVID, I think, had a big impact on this stuff. And there's and I think the research you mentioned about the nonprofits, I think the author of that, well, never mind, I won't get too far off a tangent, but there continues to be really interesting research on these questions. But okay,
I just want to add I have a couple of questions. First of all, I just want to make sure that these new crime rates that Tom is reporting are for 2024. So they do not, we should not credit nor blame Prop 36 for any improvement here, along with from Priscilla's slide. So the new Prop 30 is these crime is going down prior to the enactment of Prop 36.
Right, and it's going down basically across the country, obviously exceptions to that. And I think it does continue to do that in 2025 in pretty similarly dramatic ways for some of these offenses. All right,
Tom, so are you going to get to the youth data, or is that?
I am.
This is going to answer your question, Priscilla.
Well, and it's going to raise a lot more questions, I think, actually. Caveats. Okay, I went through all this already. And also in 2023, in addition to the Oakland problem, a lot of agencies didn't report. It was, and again, can we update that data now? So it's really hard to do any comparison to 2023 at this point. So all of this should be taken with a grain of salt. But when we see some of these big, deep percentage decreases, like double digits, I think that's not going to change even with full data. Anyway, here's the homicide rate. This is a subset of violent crime. The homicide rate is now the second lowest ever in this data. So we can go back to 1969. The lowest rate was in 2019. And literally it's basically the same as it was in 2019. So the way I think about it, and this continues the COVID thought I had, the homicide rate at its peak and during the COVID peak in 2021 was about what it was in 2008. It took us about 10 years to get it down to where it was in 2019, and we made that same recovery in about 3 years in the post-COVID environment. So I think that's just a tremendous story that we have, is that our homicide rate is essentially the lowest it's ever been.
Sorry again to interrupt.
Mhm.
Not in this report, but in future, I think it might be also helpful to start to thinking about police clearance rates and how they might be relevant.
Yeah, I mean, those are boring because they never change. They're just always extremely low. But yes, that's a good point. PPIC has done some work around that. And there are also questions to me about what counts as a clearance with cite and release rules and Prop 47 and things like that. But absolutely. But violent crime, so it's still 10% higher than it was in 2019, despite the decrease in homicide that I've shown. That's just a subset of violent crime. So I talked about the homicide rate being the second lowest ever in the data, 4.3 per 100,000. The lowest is 4.2, so that's why I say it's essentially the same. Robbery was also the fourth lowest in the data, and that includes 2020 and 2021, when a lot more people were at home and just the opportunity for robbery was much lower. So if you exclude the COVID years, it's the second lowest ever in the data. And robbery is a huge driver of violent crimes. There's a lot of those. And here's property crime, some details. As I said, overall about an 8% decrease, burglary down 9%, car theft down 15%, all larceny theft, and I'll get into that in specifics in a moment, down around 6%. Arson up 10%, but arson's a very small number, so it's very sensitive. And the 2023 arson rate, I think, was the lowest ever in the data. So we're going 10% up from the lowest that ever was. The burglary rate in 2024 is the lowest in the data, and the 2023 rate was the second lowest. So the burglary rate is extremely low, and the overall theft rate, that's all theft, is the second lowest ever. The lowest was in 2020, obviously peak COVID time. So in some ways, it's the lowest ever. So again, there's some real highlights in this data. All right, I want to dive into a few specific offenses. So the larceny theft, the overall offense, has 8 subparts we can look at, including shoplifting, taking stuff from cars, taking car parts. And this just shows you sort of, the different things we track. This is monthly reports of each of those subtypes from 2019 to 2024. So I'm going to focus in on the shoplifting and the theft of car parts, which includes catalytic converters, 2 things that, have received a lot of attention. So this is the shoplifting rate. So this is adjusted for population from 2013, so right before Prop 47 to 2024. Rises slightly after Prop 47 goes in effect at the end of 2014, comes back down, drops dramatically in the first 2 years of the COVID pandemic. Theme we've seen starts rising, rose a lot in 2023, rose a lot in 2024, and is about 50% higher now than what was before the pandemic. Here's another view of that data. This is monthly reports. So this is not adjusted for population, just how many calls to the police are there about this, basically. And again, we see a similar dynamic, but this shows that it's just been going up steadily every month since around the middle of 2021. So that is not a good trend. I think this one is particularly sensitive to reporting as well, because if you look in some counties, you see a huge increase in reported shoplifting that just continues, and it seems like maybe something has changed at particular retail stores or something about reporting. But this is what the data shows. I think it's fair to show. We see the opposite trend with theft of car parts. Again, catalytic converters and things like that.
I'm sorry,
Yeah.
I keep on interrupting. I remember that we also had on at one point the head of it was either the California or the National Retailer Association, where basically they were saying, correct me if I'm wrong, that shoplifting has not changed dramatically over time. And
I think, well, no head of the retailer association I've heard has ever said that in recent memory. So I think
she did acknowledge that it was.
Yeah, I think, and I believe it was Rachel Michelin, and I think she said they need to be better about reporting and having data. And if she came to us, before July of 2023, this chart would have ended, here, where it looks like shoplifting had not really increased compared to the pre-pandemic world. But more recently, we're seeing a different trend.
But I think Mike, there was some good reporting in the LA Times about the data that we've received, the public has received about, retail theft and sort of it being commingled with shrinkage and other kinds of losses that aren't the kind of like, shoplifting that we're thinking of, or the kind of, smash and grabs that were so prevalent in 2023. So, whether she said it to the committee, it's certainly been documented by places like the LA Times.
And Tom, does this, I agree, does this shoplifting data, shoplifting, does it include the shrinkage and the internal theft by employees?
It should not. I'm so glad you asked this question. It's one of my favorite things to talk about, as Rick and Joy will tell you, is that this definition of shoplifting comes from the FBI, and it's their own special definition that does not map on to how shoplifting is defined in California law. So, and the point of that is FBI wanted to be able to compare apples to apples across states. They said, whatever, however you classify it in your state, this is what we're going to call it for these purposes. So shoplifting here is someone taking something of any value from a store. So it shouldn't include, shrinkage and things like that, unless someone has been identified as taking it from the store. So like internal calculations that retailers do about what they expect to see on their shelves and are not there. There has to be sort of an identified act of actually removing it from the store, but it can be $10 of value or $10,000 of value. That would all be, it doesn't depend on how much it's worth. Like we have this $950 cutoff for the shoplifting offense in California. So when people talk about retail theft, they'll also include the shoplifting data, non-residential burglary, which is burglaries, which under the FBI law is much narrower. Or FBI's definition is narrower than California law, where you actually have to break into somewhere for it to be a burglary. And a non-residential burglary is just a burglary that isn't a house, so it includes lots of things that are not stores as well. So people kind of put those together to come up with a retail theft rate, and it's some kind of approximation, but I think it has a lot of issues, and it's hard to track that with our policy changes, because the policies we're changing are a little bit different than what's measured. Anyway, enough about that. Let's look at the catalytic converter and other car part theft rate. So we see sort of a different story where in the early years of the pandemic, we see this rate go up a lot and then start to come down more recently. And again, this is another view of that data. This is monthly reports, and we see that it's been coming down sort of consistently since reaching this peak in 2023. So that is the crime reports. I wanted to look a little bit at arrest and jail and prison populations too, since obviously they're related, and and the arrest data also comes out at the same time. So here's the overall number of arrests in California. This is juvenile arrest, adult arrest, misdemeanors, felonies. This is just everything in one place, not adjusted for population. We see, at least in this time period, a pretty big, more than 1.5 million people being arrested, coming down pretty consistently. Big drop during COVID, and it's, we've sustained that drop basically, which to me is interesting, that these numbers haven't sort of gone back to where they were before the pandemic. This is similar to what Steve was talking about with the prison population. I wanted to do a little bit of a deeper dive into this for you all as well. So what are the types of arrests? Here we see sort of the 6 big categories. The blue bars are adult arrests. The orange ones are juvenile arrests. The most dominant one by far is adult misdemeanor arrests, followed by nonviolent felonies for adults, then violent felonies, and a similar dynamic with juvenile arrests as well. But most of the people being arrested, it's for either a misdemeanor or a nonviolent felony.
And do you know the percentage of folks who get booked into what qualify? What's an arrest in this? This is not jail bookings.
Correct. And that's a good question. And I think that's part of how we're defining a clearance too. I think this is people who are taken into custody, maybe not necessarily taken into jail. So there's probably a big overlap there, but we're looking at arrest by law enforcement. But that's a good question. I should have a better answer to that. All right, so this is going back to 1980. Adult arrests by type adjusted for population. So this is the arrest rate. I just wanted to show, some changes over time. That last graphic I showed you only went back to the early 2000s. This one goes back even further, and we're able to see that our arrest rates have really gone down. And it's, a big drop in arrests for misdemeanors, which is this sort of, I don't know, what would you call that? Turquoise? I don't know. And then darker blue and red here is the violent ones. So this is to sort of set a baseline, because the next one I want to show you is for juvenile arrest. And now before I go to that slide, note that the rate here on this top line is about 8,000 arrests per 100,000 people. That stays the same for juvenile arrests. It's the same scale, same access, but it really drops down quite significantly to where we are today, where the number of kids being arrested has just dropped really, really significantly over time. And seems to be staying that way. And I think this is going to drive future reductions in adult arrests, adult jail populations, and adult prison populations. And I think it's a really notable trend. All right, let's look at our jail population.
Let's go back for a second. Tom, why do you think starting in 2010, the rate dropped so dramatically?
Lots of people are looking into this, but Mike's trying to get me to say what I call my Andy Rooney theory, which is this is also when we start to see, smartphone adoption, and we start to see, I think there's other data showing there's a lot less other kind of risky behavior by teenagers after that happens as well too. So maybe related to that, may not be. I mean, we see big drops before that as well, but there does seem to be something about this curve around that time that seems very enticing.
You're dating yourself by referring to Andy Rooney.
I thought some people would appreciate that. There was a reference to him on the Daily Show on Monday, which put him in my mind. Anyway, here's our jail population. So this is average daily population in all the jails that report data to the Board of State and Community Corrections going back to 2005. Realignment, we see an increase in the population, Prop 47, a big drop. Biggest drop of all, though, was caused during the early days of COVID. And like the arrests, we're not seeing a recovery to that pre-COVID population. This seems to be a sustained drop. Obviously, there's, it's not totally consistent, and some jails are probably more full than they were before. But as a statewide system, you sometimes hear these statements that our jails are overcrowded. Either that isn't true, or it's a lot more nuanced and having to do with availability of beds for certain security levels and things like that. But just as an overall population, we're much lower than we were before the pandemic, and obviously before Prop 47 as well.
Your screen is zoomed in a lot. Can you unzoom it?
Oh, it is? Huh. Is that any better?
A little bit more would be better.
Okay. How's that?
It's still not centered. It's a little bit, we can't see the full graph, is what I'm trying to say.
That's why it looks, I'm a little bit at a loss because I haven't done anything.
It's flashing back and forth.
You want to change the mind, Tom? I could show the last one if you want.
Yeah, sure. Let's try that. See if that's any better. Good idea, Rick. Thank you. And the last one is prison population, which it's the same story. Is we see a big drop during COVID, and it's lower than it was even then. Yeah, perfect.
You go back to the jail one too. So we were at 80,000 pretty consistently up until realignment, and now we're down to 60,000 people average daily population, which is obviously good news.
And to what extent do you think changes in bail practice have impacted the declines in the jail population?
None, unfortunately. I say that for two reasons. First, what you hear from public defenders and other people in courtrooms, and the second is we did a study with the California Policy Lab about the LA jail in particular, about the impact of what they call PARP there, which are the pre-arraignment release protocols or something like that, that basically specified immediate release for most misdemeanors and nonviolent felonies. And it had a very small impact on the LA jail population. So I think we just aren't seeing much of a change based on that. That's my instinct. I haven't thought about it more deeply than that.
And what do you think, aside from COVID, is it just a cascading effect of fewer arrests, fewer people in custody? What do you think accounts for the decline? The sort of top line.
I think it is. It's not really an answer, but it's got to be. There's less arrests, so there's less people to be brought into the jail. And, probably some of the measures that, Judge Espinoza talked about, mental health diversion and other things that are taking some folks out of the jails are contributing. But, we see it just, the graph looks almost the same for the arrest rate as this one. You can almost lay them on top of each other and they look very similar.
Do you know, like, I guess this is a question that I want to join with Chair Romano, but I'm also interested in whether, for example, complaints or calls for service have decreased, and so therefore, which might
Mm-hmm.
Yeah,
um,
911 calls is
yeah, so like, are people just not calling the police for a variety of reasons, including immigration, including fear of the police, or, not viewing the police as, legitimate, coming after George Floyd?
Mm-hmm.
I'm wondering if those explanations have been considered or if we've looked at that data.
That's a great question. I haven't thought about that. I don't know of I'll have to see, but I can't think of a place that has that data sort of available for anywhere big in California, though hopefully I'm wrong about that.
Yeah, and also, I mean, hopefully a lot of this is driven by less crime.
Right.
That's the best possible explanation.
Right. Crime it's been a little bit of a different story. It's not, just one trend like we're seeing with arrests and these correctional populations, but yeah, there's some relationship there, obviously. All right, now it's Rick's turn.
Did you do this last slide about the California?
Oh, I think maybe very briefly we did it, but it's the same trend. It's, that big red bar is our peak population, around 170,000 people in 2006. And then, you can guess when realignment was from that big drop, and then COVID in 2020. And again, we're seeing a sustained drop in the population.
This question is for both the jails and the prisons. Are we seeing any, since we've been talking about disparities, are we seeing any disparities in terms of who benefits or, changes in population? So, the overall population is decreased, but Latinx people haven't benefited as much. It's not consistent with respect to African, Black folks. So are there any outliers in terms of this downward trend? So for example, when I was on the commission for the sheriff's department, we learned, the populations had decreased, and we were particularly looking at mental health populations. But then when we looked closer at the data, we could see that Black men didn't benefit as much as one might expect from the decreases. So I'm wondering if there are any data points that we can really delve into to look at how different populations are faring in this sort of downward trend with regard to populations in jails and prisons.
So on jails, unfortunately, there is no demographic data, I think, beyond gender that's reported on a statewide basis. The most recent, I think, is from 2019. On prison, there was a presentation that Steve Raphael did this morning, I think before you arrived, that addressed exactly that issue. And we do see big drops in relative racial disparity, particularly for Black people, in the last 5 or so years in the imprisonment rate. And then some of the work we're doing with the California Policy Lab on the resentencing policies shows that, particularly for the Prop 36 three strikes resentencings, there was a disproportionate impact, I guess, in a good way on Black people too. You saw a much higher percentage of Black people resentenced as a result of that policy, and I think a few of the other ones as well. So can't say anything about jails on a statewide basis, and the prison picture was explored a little bit earlier.
And just to highlight the mental health angle that Priscilla Ochin just mentioned, and Peter also, I know that there's ongoing litigation in the Coleman class action case. There's just a special master appointed. And according to data that was presented in that case, the total number of people in CDCR who are receiving mental health treatment has more than doubled over the past 20 years. So whether it is that we're finding more mentally ill people or more mentally ill people are being incarcerated in prison, it is the problem seems to be ironically getting worse.
Mhm. All right. I think that's it. for me.
Okay, so I'm going to do a quick rundown of our research updates and staff proposals. They're detailed more fully in the memorandum provided. And then, of course, if you have any questions, please go ahead and chime in. The first one relates to gender bias in criminal proceedings. It's an issue that was raised at our April meeting, particularly by Professor Sandra Babcock. Staff is continuing to research reforms that limit the admissibility of evidence that reflects gender bias. And this is in line with certain existing evidence code provisions, including the rape shield laws, the recently enacted laws related to creative expressions, and the well-established limitations on the use of character evidence. So each of these rules requires heightened judicial scrutiny when a party seeks to admit this potentially biased evidence. And the thought is to apply a similar framework to address gender bias. And so our next steps here is staff is continuing to work with Professor Babcock and her team. She has a team of summer interns, law student interns who are reviewing appellate court decisions, who are contacting public defenders' offices, who are trying to get a real firm grasp on the type of evidence that generally comes in that reflects gender bias. We're trying to categorize that evidence. And we are going to develop a proposal that we'll submit to the committee at an upcoming meeting.
As always, I'm especially curious about if other states are good models.
Noted. Thanks.
And not that we've heard, and I feel like we would have heard by now, Rick, don't you think, given
Yeah,
the
I think so.
scope?
We haven't heard, but of course, yeah, we'll always look into that.
But it's also valuable for us to be the leader on this, and California can and should be. But anyway, you get point made.
Yeah.
Right. All right, our next research update is related to the coercion defense. Staff had previously proposed developing a non-exhaustive list of factors that help courts and practitioners determine when an offense is the direct result of IPV victimization or human trafficking. Right now, the coercion affirmative defense says you could basically present this defense if it is the direct result, but there's no guidance given to courts or practitioners and to decide kind of what that means. And so staff had proposed developing a non-exhaustive list. We are still kind of kicking around this idea with the experts to decide whether, this factor-based approach is helpful in the implementation of this law. All of the focus in that community right now is on a bill that's pending in the legislature this year, AB 938, which would apply the coercion affirmative defense to all felonies. Right now, it's limited. And so that's where the focus has been, but we have continued conversations with experts about that to decide whether, that list would be helpful. And also, if that list would be helpful, we're trying to better identify exactly what the factors should be. And so we're continuing work with that. Okay. The next research update relates to the coercion-based vacator motions. There had been a question about whether courts can appoint counsel for these motions. There's a existing law that allows courts to appoint counsel for any ameliorative statute, but there was a question about whether the coercion vacator law fits the bill. Since we've had that question, AB 938 has been amended to specify that these coercion-based vacator relief petitions do qualify for the appointment of counsel. That bill is pending in the legislature, has passed the first House of Origin, and has passed through its first committee. I believe in the Senate, it's in Senate appropriations. So it's a wait and see like everything else.
And just to make sure, we asked that they add that to it, in response to some of the things we talked about here. So it's, it'd be a great way to get something else done this year.
Okay, moving on to our first staff proposal. It's to allow habeas relief for people convicted of a failure to protect murder under before the California Supreme Court's recent decision in Collins. And current law allows habeas corpus relief, a specific avenue for relief for people who were convicted of a crime before the admissibility of expert testimony on IPV. And so the proposal here would be to extend that relief to allow people to return to court if they were convicted of a failure to protect homicide, but that they likely would receive a different result if the new clarified standard in Collins was applied. Any questions there? All right, moving. Oh, sorry. I won't spend too much time on this one. It's the staff proposal related to establishing a new specified standard for self-defense cases in scenarios where there's IPV. Under current law, things like imminence of the threat and a requirement that the person act on fear alone are strict requirements that are threshold requirements to a successful self-defense claim. And so the proposal here is to create a new standard of self-defense to apply in IPV cases that makes those things factors for a jury to consider and not strict requirements. And Joy is going to present our last proposal on blanket 1170.6 disqualifications, I believe.
Want me to go through it real quick, Joy? Okay. So this is following up on the meeting we had in May about blanket disqualifications, where a prosecutor, public defender, typically an office that appears a lot, will kick a judge off a type of case or all criminal cases. And we've modeled this proposal basically on a law that Oregon passed a few years ago that has been very successful, and that we've heard that there's not been a blanket challenge since. So we're really trying to think of something that will limit abuses of blanket challenges and not necessarily get rid of them entirely, and not touch at all the use of one of these challenges on an individual case. So we try to take a very targeted approach. And it's got, basically three parts to it. The first is we have to define what a blanket challenge is. I think it a little bit has an appearance of, when you see it kind of vibe right now, but it should be defined pretty broadly. So it shouldn't just be the judge is disqualified from hearing all criminal cases, but it should be, a little broader than that, would include a particular type of case like mental health court or mental health diversion, or, the arraignment judge or something like that. So a relatively broad definition. And step two, you'd allow the judge who's challenged, or the presiding judge who might have a better sense, or, reputationally be more ready to do it, to request, to challenge basically the disqualification and say, you need to put forth some evidence showing why this judge is prejudiced against you, which is what the statutory standard is. And you'd have a judge from another county determine that. And then the third part is how the parties making the blanket challenge would, be able to justify it. Basically, it'd be a very low showing, a good faith belief, but with particular facts, the judge's prejudice against the office or the attorneys, or whatever the interest is. And so you couldn't just file a single piece of paper, get the judge disqualified. You have to justify a little bit more. And if a party is willing to do that sufficiently, they can still do it. But this should sort of curb some of the most egregious abusive cases. Yeah, Professor Rum.
Are you anticipating that the first limitation will cover one of the issues that we spoke about at the meeting, where, some judges are just so not defense oriented that almost every client of a certain, like a public defender's or an alternate public defender's office may move to disqualify, but that wouldn't qualify. Would that not qualify as a blanket challenge? I can't quite tell from the way that first limitation is set up.
I think it would. And again, we'd want to craft a sort of big enough definition, because you wouldn't want there to kind of be games about it. Like, I challenged you in 80 out of 112 cases. That seems like it would be enough. So I think in that scenario, yeah. So there's sort of a consistent, coordinated maybe coordinated wouldn't be necessary, but a consistent challenge to the judge, I think, would be enough to require a hearing on it, see what's going on. So yes.
Yeah, I mean, I think that, I mean, you know, it's the same problem I raised at the meeting. I'm not sure this quite captures it. There's a difference between a prosecutor's office, you know, disqualifying a judge in a certain percentage of cases where the interest is exactly the same in every case. It's the people. But there's a difference when you have individual defendants. Like, you know, I assume most of the attorneys are in a certain office are giving their clients the same information about the judge, and the clients are making individual decisions about what to do. But it may be that based on that information, 80% of the clients decide to disqualify or paper them.
Mhm.
And that's a very different situation than if the DA's office is doing it 80% of the time. That's not an individual decision, that's an office, you know, interest of the people of the state of California. This isn't, and I just don't want to do anything that would undermine, you know, individual defendants' rights to make their own determinations based on the information they get, with maybe the same information from various attorneys. That was my concern that I raised at the last meeting, and I want to make sure that our recommendation captures the distinction there.
Well, one, you know, some states in the original California version of this law only apply any restrictions on this sort of thing to prosecutors. I mean, that's one way to do it. And obviously, if the committee wants to add that, that's easy enough to do, as you know, conceptually. But you know, it would take the recommendation in a bit of a different direction, which, you know, that's, if there's interest in that, let's do it.
I think there's enough of a distinction between the two interests of a public defender's office and a DA's office on this issue that it's worth considering. I understand the political challenges of that, but you know, we talked a lot about this at the last meeting. If a DA's office papers a judge, they're out of business. Like they, you know, they can't sit in the criminal court because the DA's office is on almost every single case. You know, if individual defendants, maybe even if they're predominantly represented by the public defender's offices, make those individual decisions, there's a lot of different interests and factors to be considered. I think it's worth treating the two offices differently, but maybe we need to have more discussion about it before we go that route.
I agree with Heidi. I do think there could end up being a issue in the legislature if the DAs really come out and oppose it. But I think that it is I think it's a different scenario. Just to cause a little trouble late in the afternoon here.
No, it's good. And, you know, at the meeting, we had Judge McGuire from Yolo County and DA Dan Dow from San Luis Obispo. And we had asked them both to sort of canvass their respective groups. DA Dow is the current president of the District Attorneys Association, and Judge McGuire is active in the California Judges Association. And they both sent back sort of, you know, data, I guess, about the use of these blanket challenges. And you know, the CDA data, a lot of it was about how public defenders use them a lot, which is maybe not surprising. The data from the judges was there isn't a clear sort of lopsided use by one side or the other, probably prosecutors a little bit more than public defenders. So I know that was one question we had. It was this sort of a tool that was used by one side or the other to oversimplify a little bit. And based on this very imperfect, rough collection of information, that doesn't quite seem to be the case. But that doesn't really answer the underlying question of, you know, the interest and the effect might be different depending upon who does it. I mean, as I said, conceptually very easy to make that distinction. So I think we can just sort of reserve, you know, we can let this percolate a little bit more, because it wouldn't be a ton of work on our side to, you know, update it along those lines. All right, I think that's it then. Public comment time?
Before we get to that, I just wanted to add one piece to the maybe it fits best under the pending legislation. I forget if we talked about this at a previous session, but the LA Times reported that the governor's office is considering new regulations that I think are based, at least, or encouraged by recommendations that we made to allow BPH to review life without parole sentences for possible commutation. I don't think that those regulations have been published yet, but they indicated to the Times that those regulations were coming soon. And Tom, correct me if I'm wrong, that we issued a recommendation along those lines some time back.
Yes, that the recommendation was that LWOP sentences should be reviewed for sort of clemency or resentencing. I think after 25 years, that was a recommendation made, I think in 2021, so a while ago. And from what I understand about the regulations, it's not been stated publicly exactly who would be eligible, who would or what who would apply to. I think the assumption is it would apply to people with LWOP sentences, but I don't think there's even really been a clear statement about that. And I think there'll be more information coming out by the end of summer.
I think that that recommendation predates me, but I'm curious whether we recommended any exclusions. I would assume that we wouldn't believe that anyone should be excluded from at least consideration of potential parole eligibility based on good behavior.
Your instincts are correct.
Okay, thank you.
And also, just to close that loop, I believe Jennifer Schaefer testified before this group in support of that type of reform.
Yeah, it's my understanding that there's been an idea for something along these lines, for quite a while. And it was the, Menendez brothers case that has put a lot more attention from the media on it.
Who? All right.
I'm sure there's some days you wish that was true, but anyway.
Thank you all. Again, I think this has been incredibly helpful and informative, to me at least, session. Thanks especially to Tom, Rick, and Joy, and all of our witnesses who have come before us. We're going to open it, the session now, to public comment. If anyone is in person and you'd like to speak in Sacramento, please line up and let us know. I'm assuming that most of everybody is listening by Zoom, and to get in line to comment, please use the raised hand function of Zoom. If you're calling in on your phone, hit *9. Please, everyone, note that this meeting is being recorded and that if you make a public comment, your name and/or phone number may be displayed as part of the recording. I'm going to take a minute now to see how many people want to comment, and based on that, I'll decide how long each person has to comment. Please note that the committee also accepts public comment in writing. That comment can be emailed to committee staff, whose emails are on the committee webpage. I also want to ask that please, if you could, try to focus your comment on issues that we discussed today. That is always the most helpful comment that we have. So with that said, let's see how many people raise their hand, and then we can go from there.
I think we've got 5 folks so far. Should we get started?
Sure. I think we normally allow for a minute and a half, so let's try to keep it to that. And with that, Xavier from Silicon Valley Debug, thanks for joining us, and your minute and a half starts now.
Okay, thank you. Hello, my name is Xavier Spong. I'm a community organizer with Silicon Valley Debug. I support families who have loved ones that are incarcerated. And reviewing the mail from incarcerated individuals, the need for further RJA reform is clear. Over 80% of all mail we receive involves incarcerated people asking about data that is similar to their case to show the racial bias they experience, or asking about the process for reviewing their case for exhibitions of explicit or implicit bias. They need lawyers to navigate them through the complexities of this process. The letters I receive come from diverse racial groups like Latino, Native, Black, and Asian that make up California's most vulnerable and over-policed communities. To get around these issues with data accessibility and lack of appointed counsel, we have seen families in an act of desperation spend hundreds of dollars to request data from local DA's offices to support their loved ones' petitions, all for this data to be unusable, leaving them excluded from RJA's promise. We hope that the process laid out in 745D can be followed so that incarcerated people can get relief under the law. The DA should have a continuing obligation to provide incarcerated people with necessary materials to create their own pro se petition, whether or not they are appointed counsel, including redacted police reports. Thank you for your time.
Thank you. You're right on time. And thanks also to all the folks at Debug. I'm a big fan of your organization, so thanks for all the work you do. Zach Kirk.
Hi to the committee, Zach Kirk, also with Silicon Valley Debug and a current law student. Just wanted to say that our organization strongly supports the recommendation that dismissal be added to the list of remedies. As was discussed earlier, we've seen 40 to 60 cases in Santa Clara County. Some are still ongoing, but there has only been one remedy, and that was to drop aggravating factors, which just doesn't square to what we intended as the co-sponsors of AB 256. And we've also seen cases in Santa Clara County where, but for the racist protectional stop or the reliance on stereotypes in arrest, there would be no charges or convictions at all. For that reason, we recommend that the committee recommend a test, something like, quote, but for the exhibition of bias in this case, which can be met by any claim under 745A1 to A4, the judge must dismiss the case with prejudice. This would not only be just in the attempt to eliminate racial bias in our society, but also harmonizes with the fruit of poisonous tree analysis and kind of the constitutional protections around equal protection. And finally, the initiation of criminal proceedings on the basis of an exhibition of bias based on race, ethnicity, or national origin. It often occurs where the race of an individual lowers the reasonable suspicion or probable cause standards. And to me and to our organization, this is the gravest of constitutional violations and should be considered so under law. Thanks to the committee.
Thank you. Where do you go to law school, if you don't mind me asking?
Santa Clara.
Great. Thanks for your comment. We really do appreciate it. Is it Jerry?
Chugging to me, Jerry Silva, Mike Romano.
Hi, Jerry. It's good to hear your voice.
Hi, panelists. Thank you so much for this meeting. Thank you for giving attention to the Racial Justice Act, which has been going through years of fix to try to make it applicable. Clearly, everybody here knows what a travesty the criminal legal system is. I wanted to ask a question, I guess, of Tom. When you were going through the pieces of legislation, you didn't mention Colorado's bill, AB 1071, which is a continued way to make RJA applicable and usable. Is there any reason why not? I've missed meetings lately, so forgive me if I'm missing something.
No, of course. So that bill is not based on anything the Penal Code Committee has recommended. So that list was just focused on those bills. We did talk about AB 1071 this morning in the context of the RJA more generally.
Meaning to say you have not recommended that, or you just haven't weighed in on it?
I guess we just haven't made a recommendation that made its way into that bill. It's not that the committee has considered it and voted it down or anything. It just
That's correct.
something
we haven't brought it to a vote one way or another. It's not been one of the things that we've researched, Jerry.
Oh, I hope that you will do that. Okay, next, and I'll be kind of brief on this, and that was, and maybe I felt like you just spoke to it, but the proposal, quote unquote, by Newsom to initiate a comprehensive risk assessment for others similarly situated to the Menendez brothers. So understand it's now the Board of Parole Hearings is discussing regulations and where it'll go. Has the committee weighed in on that, or taking a position on it, or what, or anything?
As we said first of all, Jerry, thanks. It's really always good to hear your voice, and everybody should know what a great advocate you've been for justice in California for many, many years. We've not weighed in specifically on the governor's proposed regulations. We haven't seen them, so it's hard to comment on them. Although from what we understand in the Los Angeles Times article, it does track very closely with recommendations that we've made in the past regarding ways to review very long sentences, and in particularly life without parole sentences. Tom, do you remember which report that recommendation is in?
2021.
So Jerry, you could find it there.
Oh, yeah, no, I definitely, I stay on top of all your recs. I'm just hoping that as this proceeds through, that this is an influential body. You might have some means to support moving this forward. Thank you for the time, and I appreciate you too, Mike Romano.
Thank you very much. Cecilia Chavez.
Yes, good afternoon at this point. Thank you so much for having us share some of our thoughts. I want to first and foremost thank for compiling some of that data and creating the tool that was earlier displayed, Mr. Romano. That was really helpful. I think this speaks to how critical this information is needed by the public, who needs to know, who needs to have access to this information to even present this information to make a claim. I want to, we have so many people that reached out who are indigent and don't have access to data or transcripts that aren't even asking for appointed counsel at the point in the process. They just want to review their transcripts or discovery to try and write their own pro se petitions and receive some kind of appointed counsel. And think about even passing the prima facie standard. Some individuals have been incarcerated for decades and have lost vital discovery or transcripts, and many were never even given those transcripts. Silicon Valley Debugs asked the committee to recommend a mechanism that compels the Attorney General or any other state agencies to produce this information for incarcerated people so that they could potentially look into an RJA claim. Thank you.
Thank you very much. Records and transcripts, especially in old cases, can be incredibly frustrating to get our hands on, and I certainly want to encourage any way to make that more possible. And thanks for your note about our dashboard. I'm super excited about it. I hope that came through, and we look forward to making it live for everybody in the not too distant future. I see the coalition, California Coalition for Women Prisoners.
Yeah, that's the organizational name. Hi, everyone. I'm Courtney Hansen, and you all do such important work I've been following for years. Thank you. We have been with the RJA and helped pass it in 2020 and are now working on the implementation, and we support your recommendations and think they could be strengthened even further, especially by hearing from organizers and impacted people on the ground who have the lived experience facing these barriers to getting the information and the legal representation, who were caught in the quote impossible catch-22 described by Justices Liu and Evans. And I really appreciate even your language saying that your task is to unlock the power of the RJA, because the legislature was very clear in its intention to eliminate racial bias, which is obviously ambitious, but long overdue and necessary. On expanding remedies, proven RJA violations must be allowed to result in the remedy of dismissing the case. We all know there are absolutely scenarios where without the bias, without the racist discrimination, there is no case at all. On data beyond prosecutors, it's vital that impacted people and their attorneys have access to information from system actors broadly, police and sheriff departments, and also I want to name probation departments, and that these bodies are held accountable to engaging with those seeking the data in good faith. I think part of the issue is a genuine need for better systems to collect, organize, and share the data. The dashboard is incredible, but part of the problem is a political will and resistance issue, resistance to addressing longstanding racism and the status quo. all parties can agree there are many barriers and burdens in the implementation. Really grateful for your thoughts around formalizing large-scale relief. We feel that's a logical and principled direction to go in. We know that these issues we're dealing with are systemic and should explore concrete mechanisms for formalizing relief to groups of similarly situated people. And lastly, it's urgent that those of us that care about equal access to justice figure out the most efficient way to go about this, including a cultural shift, which I know is challenging, where system actors actually take responsibility for the crisis of systemic racism. So I appreciate some of the tougher questions asked to the DA. And I just want to give an example of that. Mr. O'Connell kind of using this example of, oh, sometimes over time, what's culturally acceptable changes. We have recent egregious examples of obvious racism where courts have failed to find a showing or a violation. Like long held biases being invoked about men of color preying on white women, totally dehumanizing language, predator, monster, uncivilized. And lastly, the immigration consequences and the protective potential of the RJA is all the more urgent right now. So I want us to just keep that in the frame of mind too. And of course, we appreciate all your work on gender bias. Thank you so much.
Thank you so much. You know, the immigration angle on so many of these cases, it's something that we do not probably discuss enough. I think that reflects a little bit of a bias that those of us on the committee are not really immigration experts, but I really do appreciate the point and it's well taken. So thank you.
Thank you. And we have examples just in the future, if that would be helpful to see how that's playing out on the ground. Thank you so much.
We should definitely keep our eye better on that issue across the board.
Thanks.
All right, I think we've come to an end. It's another long day, a productive one, I think. Thank you all. It's a privilege to be part of this group. I really appreciate everybody's work. And you know how to reach us. You know how to reach me. Unless anybody else has any more to say, I'm going to close the meeting and adjourn and see you next time. Any last words for the good of the order? All right. Goodbye. Thank you
Thanks.
all. Have a good afternoon and rest of your week.